All right. Good evening, everyone. I am Jamie Herman. I am an associate director out at the Janet Prindle Institute for Ethics, and I am very happy to invite you to our event this evening, which is Courageous Conversations in Ethics. This is a program that we run out at the Institute, a series where we examine challenging moral issues from a variety of perspectives. These are not debates per se, but rather an opportunity for people with different perspectives on the same issue to meet and come and engage in a dialogue. We think it's important to have these sorts of conversations. And while our discussion may be friendly and respectful, we're hoping not to shy away from disagreement this evening. Tonight's event will feature a moderated discussion between our three panelists, and after this, we will open it up to Q&A, where we would love the audience to engage in questions to continue the discussion. The theme for tonight's discussion is the limits of zealous advocacy, a crucial topic in the realm of legal ethics that explores the tension between an attorney's duty to their clients and their broader moral obligations to the justice system and society at large. So, with that, I'd like to introduce our panelists for the evening. Our first panelist over on the left is Brad Wendel, a professor of law at Cornell Law School. Before entering academia, Professor Wendell worked as a product liability litigator, served as a law clerk for the U.S. Court of Appeals for the Ninth Circuit, and his research and teaching focus heavily on the application of moral and political philosophy to complex problems in legal ethics. His most recent book, titled Canceling Lawyers: Case Studies of Accountability, Toleration, and Regret, is one of the reasons he's here tonight on this panel. Seated next to him, our next panelist is David Luban, a university professor of law and philosophy at Georgetown Law School. His scholarship explores moral and legal responsibility in organizational settings, including law firms and the military. And he is the author of several highly influential books, including Lawyers and Justice, an Ethical Study, and Legal Ethics and Human Dignity. Professor Luban also has testified before both branches of Congress. And our final panelist for the evening is Paul Felix, a judge of the Indiana Court of Appeals. Appointed to the appellate court in 2023, Judge Felix brings extensive practical experience to the panel, having previously served as a Hamilton Circuit Court judge for 14 years. Throughout his career on the bench and as a former deputy prosecuting attorney, he has been a strong advocate for youth assistance programs and evidence-based justice initiatives. And our panel this evening will be moderated by Jeff Dunn, who is the director of the Prindle Institute and who is also an associate professor of philosophy here at DePauw. So with that, I'd invite you to join me in welcoming our panel.
Cool. Thanks so much, Jamie. So let's get started. I wanted to get some case studies to kind of focus our attention on what the topic is, but I want to just get straight to the title first, I think, of the panel. So let me just set this up a little bit. We're all familiar, I think, with cases where because you occupy a certain role, you're allowed to do certain things you wouldn't otherwise be allowed to do. So for instance, if I'm the coach of the team, I can maybe criticize how a player is playing, but if I'm a parent in the stands, maybe I should refrain from doing that. I'm not occupying the right role. So there's similar questions, I think, about the role of lawyers and what they do in that role. And that's kind of the topic what we want to talk about today. And it relates to this term zealous advocacy. So I just want to start there, and then we'll get some case studies on the table. What do we mean when we say zealous advocacy? This is kind of maybe a term of art in the law. But anyone want to jump in?
Sure, I'll jump in. So let's just take it one piece at a time. Advocacy means just what you think it means. It is arguing on behalf of a client in an adversarial setting, which can be a courthouse, but it could also be a very contentious negotiation. So that's the advocacy part. Zeal means that that you're not holding back. That even if you have some private compunctions about what you have to do to advocate for your client, or if you have some private compunctions about whether your client's case is even worth advocating for because your client wants something that you think the client isn't entitled to, you nevertheless don't hold back. That doesn't mean that you start yelling, or as like one famous lawyer would reach across the table and grab another lawyer by the necktie. This was the most successful mergers and acquisitions lawyer in New York, but never mind. Um, you can be civil, but it means that you set aside any private reservations that you have and go in all the way.
So just a little bit of an inside baseball thing. The term came into the law governing lawyers, which is a subject that I teach, distinct from the ethics of lawyering, by the way. It's the law of lawyering. In a thing called the Model Code of Professional Responsibility in 1969. And I think the genesis of the term actually goes back to some famous cases where lawyers were defending unpopular clients. I think, the trial of John Peter Zenger, or John Adams representing the British soldiers in the Boston Massacre trial. Those cases where lawyers, resolutely stood by an unpopular client started getting shorthanded with this idea of zealous advocacy. And so David's right about, the zealous part, and theoretical legal ethicists talk about the standard conception of legal ethics, which has these principles of partisanship, neutrality, and non-accountability. That's what I think that's meant to be a shorthand for. But lawyers started overusing it a lot. And one of my big pet peeves with the term is that lawyers use that across the board for all lawyering contexts, including advising and counseling and transactional work, where there is no advocacy going on, in the sense that there's no opposing party. The lawyer is providing advice to a client about what is permitted or required by the law, and is in effect kind of a private lawgiver, as opposed to someone putting forward a position which can be challenged and then ruled on by some kind of neutral. So I strongly dislike the overuse of this term. But at its best, what it's meant to do is signify the kind of single-minded devotion to your client's cause, regardless of, clamor and alarm that you might cause. That can be a good thing if you're a public defender or if you're representing an unpopular client, but the term is susceptible to being overused. And so I get a little snide when I see that term.
One thing that I think is important when you're trying to define what any word is, or what a phrase might be, or concept, is not only try to define what it is, but what it is not. And one of the things, so in my role as a trial court judge and now an appellate court judge, as young lawyers attempt to enter into the Indiana bar, I have been assigned the responsibility of doing what's called character and fitness interviews, which is just as much a part of the entry into the bar as taking the test is. So you have to pass this interview just as much as you would have to pass the test. One of the things I always talk about with applicants as they are entering into the field of law is that zealous advocacy does not mean that you take advantage of other lawyers in their personal issues or things that might be happening. And I always give the example that if you are preparing for a trial and your opponent, the lawyer on the other side, calls you a week ahead of time and says, hey, I need a continuance because my husband just got into a car accident and I'm going to need to be with my husband. Will you please not object to this continuance that I need when I file the motion to continue? Right? Zealous advocacy does not mean I'm going to object, because if you're not going to be there, then I'm going to be the lawyer that's more prepared than the other person's going to jump in at the last second to cover you, right? At least that's my interpretation. I hope you two agree with me.
Agreed.
There's also something to do with professional courtesy that I think puts a limit on zealous advocacy. And I always tell these young applicants, the lawyer that you're working against today could be the lawyer that you are working with tomorrow. It could be the lawyer that is helping you in your next promotion. It could be the lawyer that is your reference when you are asking for your next job. So zealous advocacy does not mean, getting in the way of other lawyers' lives.
Okay, this is great. So we're already seeing some pressures on how far zeal can extend, right? Whether it's zealous advocacy or zealous representation, maybe it's a. So can we get some other cases of? You gave one sort of hypothetical of a kind of way in which zeal might go too far, using inside information. What are some other of these classic cases where it looks like maybe lawyers have gone too far on the zealous end of things. It might make us think there's limits to zealous advocacy.
Let me just give, this is maybe the classic statement of what zealous advocacy is, and it comes from a 19th century British barrister who was representing the Queen of England in a messy divorce with the king. And he says an advocate knows nobody in the world except for the client, and will at all costs to himself and any alarms, torments, and destructions that he puts on others, including throwing his country into confusion, does not let that dissuade him. And when I first read that, I thought, wow, this sounds like a sociopath, right? Really, you don't care anything about the alarms, the torments, and destruction. You don't care about throwing your country into confusion because you know only one person in the whole world. And I mean, there is something really important about that kind of touching devotion of lawyers to clients. And I think especially into the classic cases is a criminal defendant. I mean, if you look at the title of criminal cases, it's the people versus David Luban. It's the state versus David Luban. Lawyers will often say, once you are indicted, you don't have a friend in the world except for your lawyer. And there's something about that kind of loyalty that is really important. But the alarms, torments, and destructions part has never sat well with me. And I think that there are moral limits because a lawyer is not just a robot. A lawyer is somebody who's got a conscience of their own. And you will sometimes find extreme cases where you just think about, as a matter of my own conscience, I just can't go there.
So
and I know that you've got a couple of humdingers in mind for us to talk about later. So
well, I was going to set that out, actually. I take it that Jeff was asking us to do that. So I want y'all to think about what the right thing to do is in this case. This is one of my favorite teaching cases. And don't overthink it. Just think about what is the right thing to do here. And it arises out of a criminal defense context from a neighboring state. This happened in Illinois. So two public defenders, Coons and Coventry, were representing this guy, Andrew Wilson, in a murder. And Wilson said to his lawyers, there's a guy rotting on death row right now, a guy named Alton Logan, who had a murder pinned on him, turns out later, as a result of horrible racism in the prosecutor's office and the Cook County DA's office, but he didn't know that at the time. He was wrongfully convicted. Wilson says to his lawyers, I did the murder. He was a security guard at a bank or something. And the lawyers said, well, okay. But Wilson said, I don't want you to reveal this. Now, at the time, Illinois still had the death penalty. It doesn't anymore. But Wilson had reason to believe that if he had admitted to the murder that Logan was convicted for, the DA might go back and re-indict and seek the death penalty. He was currently serving a life prison term. But Wilson said to his lawyers, I will swear out an affidavit. I'll write it out for you. You cannot disclose it until my death, but I will swear out this affidavit that says I did the murder for which Alton Logan is serving prison time. So the lawyer said, okay, he writes the thing out. One of the lawyers took the affidavit home, literally, I think, kept it under his mattress or something like that, for 21 years. 26?
26
wow.
years.
Wow. A long time. Whereupon Wilson died. The lawyers took the affidavit into Superior Court, filed a motion to vacate the conviction. Granted, Alton Logan walks. And this was immediately written up in the press, and and it came along with some of the revelations of misconduct in the prosecutor's office. So it became a very big story in Illinois. And people said to the lawyers, how could you do that? You had information that could have freed a wrongfully convicted man from maximum security prison. You just sat on it. And the lawyers said, yeah, That's what the rule of confidentiality requires. Now, when I teach this stuff to my students, they inevitably want to find some way around that. Well, there's the bodily harm exception and there's the exceptions to the rule of confidentiality. All of those have been tested, and there's kind of a solid wall of authority that says that wrongful conviction is not a basis for disclosing confidential information. This information from Wilson was protected as confidential information. They were prohibited from disclosing it. The two lawyers said that was our job. Now, they didn't simply say that was our job. They said this was agonizing. We felt horribly about this. I was racked with a sense that I wish I could do something about this, but I can't. And I am obligated. And here's this role morality thing, or the idea of you're in a role and you have permissions or obligations to do something that ordinary people would not do. These lawyers said, even though we could have freed this guy from prison, we were obligated to keep the confidences the whole time. It's a great teaching case because it causes y'all to think about what should be done in those circumstances.
So one of the examples that I think is an example of an attorney being overly zealous is going back to when I was a deputy prosecutor in Johnson County. There were several years that I prosecuted nothing other than domestic violence cases, which I was very passionate about prosecuting. And one of the things that I thought that the defense attorneys did that I stepped over the line was that they would have their client, the defendant, bring in the victim of the domestic violence offense and have a private interview with the defense attorney without letting me, the prosecutor, be aware of what was happening. So it's overstepped the line in a couple ways. One, there are actual formal ways to go about getting what we call discovery, and that is either by way of depositions or interrogatories. We don't typically do interrogatories in criminal cases, but there definitely is the formal approach of we want to interview a witness in this case. Let's get together, all of us at the same time, and interview this person. And then, of course, the other issue was not only were they not going that formal route, but they were also violating a protective order that was in effect at the same time, under the guise that as an attorney, I can represent my client and then also see this witness, even though my client is in the room where this other witness is. They were essentially violating a no contact order at the same time they were interviewing, which would have been my victim or the witness in the case. And I always got into heated debates over the appropriateness of them doing that.
Yeah, this is good. So it seems like there's some cases where maybe we expect lawyers, from an ordinary morality perspective, we'd expect lawyers to do something that they don't do. That's like reveal the information. Maybe there's cases where lawyers could use procedures that allow them to do things they otherwise couldn't do, like maybe intimidate witnesses in certain ways. And so that brings up, I think, the sort of the key tension here, which is ordinary morality versus like your professional duty. Like, how do we weigh those against each other? And Professor Luban, as I read you, you suggest that sometimes lawyers should actually follow ordinary morality rather than professional duty in some sense. Is that right?
That's, yeah.
And if so, could you give an example of that and kind of say why you think that might be true?
Yeah. Well, I'll just start with a premise that I already mentioned, which is that you don't stop being yourself when you step into the professional role. And even if the law of lawyering says that you have this duty of confidentiality, just to go to the Alton Logan case, there's always a question, do I follow that duty or do I not? And what are the costs and benefits? Have I violated an oath? Am I violating loyalty to my client? Is there a reason for an absolute exceptionless rule of confidentiality? And if there isn't a reason for it, then maybe the reasons that I have to break that rule of confidentiality are stronger. So let's just dig a little bit deeply into why we have a duty of confidentiality for lawyers. One reason is people are trusting you with personal information. And it's, you're trying to protect your client's privacy. In many disputes, both parties have acted badly sometime or other, and you want them to not have their bad facts sprayed all over the world. And secondly, they might not tell you things if they didn't think that you would keep them confidential, things that you need to represent them adequately. So there's a kind of duty of an important for you to do your job correctly. And then there's a systemic reason, which is that if unless the lawyers are doing their job conscientiously, the court can't come to the best decision. I mean, I think those are all strong reasons to have a duty of confidentiality on the part of lawyers. Are they absolutely exceptionless? Well, no. Over the years, even the profession has started to gradually say there's got to be some situations in which that duty has to give way to other considerations. The profession has wrestled with that for years. There's an exception where, one that Brad mentioned in passing, to prevent death or reasonably certain death or bodily injury to another person. After some squabbling, the rules writers also put in an exception for damage to the serious damage to the financial interests of other people, especially if you, the lawyer, were involved in causing that damage. So, two states, going back to Alton Logan, Massachusetts and Alaska, have put in an exception for cases in which somebody is facing wrongful execution or wrongful incarceration. So the worry is always, if I violate this rule of confidentiality, is that going to bring down the system in some way? I'm thinking, well, there are a couple of states that have said, no, we've got this exception for an Alton Logan case, hasn't brought down the House. So maybe an empirical premise that the duty of confidentiality rests on, which is that it would do severe damage to the adversary system, to the justice system, if you weaken it even a little bit, maybe isn't true. If it's not true, then why don't you think this is one of those cases that's exceptional? Because the one thing, I mean, I was reading a couple of articles about lawyers' responses to the Alton Logan case, and they emphasized the agony of the lawyers. Well, okay, that's kind of a lawyer-centric way of thinking about it. How about Alton Logan, who spends 26 years in prison for a crime that he didn't commit, that other people could show that he hadn't committed, and they sat on it because their own client, who was at the time he told them, I think this is, you didn't get this right, their own client was on death row already for two murders of safety officers. And he was kind of gleeful about the fact that, well, I'm not, that this other guy is going to go to prison. That's a little color embellishment that I don't think helps.
Why it's a jerk, okay.
Yeah. Well, he's a jerk. He's already on death row. And Alton Logan came out pretty damaged. The state of Illinois eventually paid him a few $1 million for the wrongful imprisonment. But I don't, I feel for the moral injury of the lawyers. I feel more for the moral injury to Alton Logan from the fact that the lawyers put rigid rule following ahead of what seems like the decent thing to do for a fellow human being.
Yeah, no, yeah, that makes sense.
End of sermon.
No, that makes sense. And I wonder, yeah, we're done. No, how would you? I get the point that like any like deviance from the rule doesn't necessarily bring the house down. But is there a worry, and maybe Professor Wendel, you want to comment on this, or Judge Felix, that like there's a problem with individual lawyers each trying to decide in every moment whether or not they can make an exception? Because that there might be a worry there that individual lawyers feel too much freedom to bend the rules, and it gets bent too much so the thing does break. Is that a worry? Or
Well, you set up nicely my position, which this is what I think about the law in general, including the law governing lawyers, which is people disagree about all sorts of things. And you can see sensible arguments on both sides of any issue. The confidentiality rule is something that lawyers have debated for a long time. There was a huge debate around the financial frauds exception. There are debates around the scope of the bodily harm exception. And this is the sort of thing that people reasonably can disagree about. And the point of the law, and this is really foundational to the way I think about legal ethics, the whole point of the law is to come in and resolve these things and say, okay, I understand that reasonable people can disagree about this. I get that. But we have to have some position that stands in for what we think people ought to do in these circumstances. And this becomes the position of the political community. We supersede the disagreement in a way with this position. So David was trying to bait me here by saying rigid rule following. I don't call it rigid rule following. I call it fidelity to law. And fidelity to law is important because the law has this moral purpose. So there's a famous influential paper from 1986 by a guy named Steve Pepper. And David wrote a really great comment on that paper. And I really I like Steve. I dislike the title. It's called The Lawyer's Amoral Role. And I go, whoa, 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 whoa. It's not an amoral role. The morality of the role is oriented toward sustaining a system that allows the resolution of social disagreement in a relatively orderly, respectful way. I mean, I'm hedging. You can hear that relatively, right? So the system is flawed. I completely understand that. But there is something morally useful in a political community to having procedures and institutions that allows the resolution of disagreement. And what that does is it moralizes our role as lawyers. So it's not an amoral role. It's a role that is oriented towards sustaining this system. So the empirical premise may be true that the system won't collapse if lawyers defect from the confidentiality rule in this case and disclose Wilson's confession. But it's the lawyer's duty is not oriented toward the result or the consequences of following the rules. It is oriented towards sustaining a system of rules and procedures that resolve social disagreement in a tolerable way. So that's what I think is fundamental for lawyers to do. And so I would have different conditions for when lawyers are permitted to depart from that role and do something like reveal the confession.
I think that the rule of confidentiality is important for a lot of the reasons that have been discussed already. But one of the things that I used to talk about with witnesses is you need to tell me what happened in a particular situation or what you're thinking about so that I know what the other people in this case may also know, and so that I can make sure that I present those facts in a more couched way so that it doesn't seem so bad as it's being presented to the jury, as opposed to letting the other side present these horrible facts that they are aware of, and they'll present it to the jury in a way that's very damning, very prejudicial. So let me know what the facts are so that I can present it in a softer way. That's one thing. One thing, as you're talking, and I hope you don't mind because I have a few questions. Because I'm hearing like, of course, we have this desire not to keep confidences about somebody who might seriously affect somebody else's financial situation, right? You got the exception there. But the law is filled with adjectives like seriously, substantially, and things. How does a lawyer, and I'm sure that's where the angst of the lawyer comes in, determine where that threshold has been met? Like somebody tells, a client tells you, yeah, I've done something that affects these people. They might lose $10,000. Is that substantial? Or is it the $1 million? Or, I'm going to do something that's going to break this person's arm. Is that when you step in and tell the police, or when the person says, I'm going to kill that other guy?
Well, the lawyer hires me. No, I mean, I consult in this area, and actually, I'm making a serious point. In addition to, I couldn't pass that joke up. But Yeah, right, exactly. Right.
Look, I just want to offload my conscience onto Brad.
So let's distinguish between my conscience. I think the interesting theoretical thing we're talking about here is ethics all told, right? Like what is the right thing to do, all things considered? That's the super interesting question. If you want to know what the law requires, you consult a law of lawyering expert. That's me. And so one of the things I tell my students in my professional responsibility class is, y'all, look, please do not, when faced with a hard question on the law of lawyering, do not, under any circumstances, consult your moral compass. That road leads to perdition, and I've seen it. Lawyers who improvise their way through a complicated conflicts problem by saying, "I'm a good guy. I'm not going to take advantage of my client. It's going to be fine." That leads to multi-million-dollar malpractice lawsuits. I promise you. The law of lawyering is law like anything else. So how do you figure out what is substantial financial harm? Go do the research. There are tons of cases on this. And if you're working with the financial harms exception, you can do some research into that exception, which really is a way of bailing lawyers out of a jam if they later find out that their services were used in a fraud and they're going to be named as a defendant. It's really kind of a variation of the self-defense exception in B4, really, honestly. But that's the thing you would know if you approach this as a legal problem. If you approach it as an ethical problem or a moral problem, you can get all tied up in knots. You might get the right answer from the point of view of morality, but you might find yourself as a defendant in a malpractice lawsuit. So let's make sure we have a clear separation between the domains here of the law governing lawyers, super interesting, technical, fun subject, and the stuff we're doing here, which is ethics, kind of all things considered.
Yeah, but that does suggest an interesting kind of tension. Like, if to be a good lawyer who doesn't get sued, you have to kind of turn off that part of your thinking. I mean, there's a tension there, right?
At least as a first cut. At least get clear what the law says. At least do that as your first cut, and then you can think about it.
What about the lawyer who is listening to the client begin to talk about some serious financial fraud or the desire to harm somebody, and the lawyer steps up and says, we have confidences except for in these areas, you might want to hold back on something like this.
Well, where the ethics on the morality on that? Yeah, I mean, to me, this is another reason for thinking that maybe we ought to think through what the policies are. If the policy behind the duty of confidentiality is we got the client to trust us with all the bad facts, well, don't we have an obligation to start off the conversation by coming in and saying, I'm your counsel, and anything that you tell me is confidential, but there are exceptions to that. At which point the client starts getting really nervous and trust is busted. Right? So does that mean that your ethical obligation is to hide the ball from your client by not saying that there are certain exceptions, like that if you say I'm going out and murdering the witness, that I can reveal the confidences. Oh, and by the way, if you don't pay my bill, I can according to the law of lawyering, I can reveal confidences in order to collect the bill from you. So, the law of lawyering is not like I mean, I think it's important, but it's got some funny things about it. I can't reveal confidences to save a guy 26 years in prison. I could reveal confidences, though, to collect a $700 fee that you, the client, are not paying.
I mean, that's the way to argue against my position. Is you find a local area of injustice and you say this rule reaches a bad result. What do you think, Wendel? And I say, yeah, that's just the way it happens. That's the way it works. Like a legal system is not going to reach a just result in every case. And to pick up on Judge Felix's point, we don't want lawyers working out for themselves in every individual case what they think the just result is. I'm not saying that that's going to result in anarchy. It's just what it is. It's a misallocation of the moral division of labor between lawyers and clients and the system. And this is something else I think is important, is that lawyers sometimes see themselves as the hero of all the stories. And they should be the ones to fix the problems and the injustice they encounter, where it might be their clients who are entitled under the law to do this terrible thing. that's where the responsibility should fall, or in the system for having crummy laws. But lawyers, come on, take off your superhero capes. You're not there to solve every single social problem. You are there to provide loyal client service and exhibit fidelity to law. And can you point to injustices in cases and embarrass me with them? Sure. But that's just that's a property of the law being general and impartial and applying, without regard to the circumstances of every single situation. That's just the way the law works.
Well, could I ask you then the question that Judge Felix threw out? What's the speech that you give your client about confidentiality on first meeting?
I would explain the exceptions. So Monroe Friedman, a famous scholar in the field, said, in order to have a relationship of trust, you have to assure the client of ironclad confidentiality. I'm not sure that's true. I also teach torts, and there are duties to warn victims who are identified by a client. So there's a famous case called Tarasoff from California, where a therapist hears from a patient a specific threat to kill an identifiable person and does nothing because confidentiality is very important to the therapeutic relationship, and it is. The patient then goes out and murders the victim. The victim's family sues the therapist, and the California Supreme Court says, yep, the therapist had a duty to warn. And so what's happened in the mental health professions after this, my understanding, is that they all now say to patients, look, we have absolute confidentiality here, except threat of harm to yourself or others, I'm going to have to disclose. And my understanding, and this is an empirical point, but my understanding is that has not caused the therapeutic relationship to collapse. The patients understand they can express all sorts of things up to this line. So I would give the speech. I would say if I'm a civil litigator, I never did criminal defense work, but if I were representing somebody who I thought might be expressing a desire to kill a witness, I might say to them, look, you can tell me anything except if, a threat of harm to someone or something like that. And then I'm going to have to disclose that.
Great. Okay, so we got kind of the theoretical dispute out here, and just wanted to point out for anyone who's taken an ethics class, there's a lot of structural similarity between the debate between what's sometimes called rule utilitarianism and act utilitarianism. Like, do you follow the rules even when they look like they've got bad results, or do you try to calculate in each instance? So there's a real interesting sort of applied debate here in philosophy. But I want to shift us a little bit and think about a couple of particular issues in private practice. We've kind of been talking about private practice mostly in confidentiality, but I want to think about a different kind of thing in private practice, and then we'll talk about the public sphere. But in private practice, what do you think about, and this has been in the news a little bit, criticizing lawyers for not what they do with their clients, but who they choose to represent. So you can probably think of cases like this. There's a recent case some people might have heard of. A Harvard law professor, Ronald Sullivan, chose to represent Harvey Weinstein and took a lot of flack from his students and from colleagues for that. There's other examples of this. Do you think that's the kind of thing we should criticize lawyers for? Do you think they're criticizable for that, or do you think, we should see them as playing a role in the system?
I just wrote a book about this. So.
Everyone's looking at me. So I wrote a book about this, which started with the observation that there is endless criticism of lawyers for the clients they represent. And one of the interesting properties of this debate is it just cycles. A lawyer represents a bad client, and people go, ooh, how can you represent this person? And the lawyers inevitably say, what do they say? Zealous advocacy. And they also say things like it's improper to attribute the client's views to the lawyer, that in order to sustain the rule of law, lawyers have got to be able to represent clients without fear or favor or whatever. And what's interesting is if you poke on this a little bit, it turns out just that the whole thing falls apart. So, for example, we think that lawyers, we should praise lawyers for representing certain kinds of clients. Lawyers will sometimes make a sacrifice. They'll leave private practice, making a bunch of money at a big law firm to represent underserved clients. And what do we say? Yay for you. Well, if all clients are on a par, you couldn't praise a lawyer for choosing to represent certain kinds of clients. So how can you criticize, right? There's got to be some symmetry there. Now, all I'm trying to do in the book, there are a couple things I'm trying to do in the book. One of the things is I'm trying to preserve the idea of a lawyer's moral agency even while acting in a role. That's something I'm obsessed with. And despite being, Mr. Fidelity to law. I think lawyers do remain moral agents while acting in the role. And I think some of the patterns of criticism of lawyers for representing clients is a way that society calls lawyers to account. So there's a thing called the principle of non-accountability, that lawyers don't have to give an explanation for themselves to others. I think that's wrong. I think lawyers do. Now, the explanation that they give can be the resolution of ethical pluralism and rule of law story that I've given. That can be a satisfactory story in some cases, but there may still be more that needs to be said. And sometimes a lawyer may need to explain why you made the choices they did, or have a ground for the choices that you make. Lawyers make career choices all the time. They go to work for a law firm that represents certain kinds of clients. They go into criminal prosecution, criminal defense work. And what is that, random? I mean, there's a reason that lawyers do this. And I just think that reasoning should be fully engaged in thinking about what lawyers do. That's not to say that lawyers are straightforwardly wrongdoers just because they represent clients who are doing nasty things. It's not a straightforward inference, but it's more complicated than saying you can't criticize lawyers for the clients they represent. That's a kind of facile move that lawyers like to make because it's easy and it kind of stops the debate. That's what I want to kind of get past. And it makes people mad. So one of the fun things about writing the book is giving talks about it inevitably gets the audience all cranked up. So this is great.
You'd say, so your answer is it okay to criticize lawyers for who they represent? And the answer is sometimes.
Yes, it's permissible to level the criticism. Now, I understand that it's unfair for a particular lawyer laboring under, we just talked about it, duties of confidentiality. They may not be able to respond. So it may be up to other lawyers to respond. So in the Ron Sullivan Harvey Weinstein case, he was a Harvard Law School faculty member. He got criticized for doing this representation by students, by the way, that he was in an advisory relationship with. He was a house advisor at Harvard. He kind of had a residential house mentorship and counseling role with the students. And they said of him, I'm not sure I'm real excited about having mentoring and counseling from a guy who's representing Harvey Weinstein. And let's assume that Ron Sullivan himself can't say anything, although he did give an interview to Isaac Chotiner of the New Yorker magazine. Not a great idea, by the way. So he may not have been able to say anything, but his colleagues kind of leapt to his defense. And they gave this standard sort of tepid defense of you can't identify a lawyer with the client they represent. Everyone's entitled to counsel, yada, yada, yada. And the students kept saying, yeah, we get that. We get all that. We want to know of you, Ron Sullivan, why do you want to do this? You weren't appointed as counsel. You're not a public defender. You took the case voluntarily. You had discretion. And by the way, in the American legal system, there is virtually unlimited discretion in client selection. We don't have something that's called the cab rank rule for British barristers, where they have to accept every case that comes to them in order. Lawyers, unless they're appointed by a judge, have almost unlimited discretion in choosing what cases to take on. So all I mean by relaxing the principle of non-accountability is it is an in-bounds question, not an out-of-bounds question, to ask, why did you join this law firm, take on this client, or whatever?
Harper Lee wrote a book about this, right? Yes. So I think, depending on where you are in your career, a lawyer might choose a client or not choose a client. A young lawyer might be who is still scratching his way or her way to the top, may be more willing to take on clients that can pay, as opposed to later in life when they feel like they've made it to where they want to be. They can now have more discretion in saying, you know what, I don't want this type of case. I don't want to represent you on this particular issue. I don't want to deal with it. But where you are in life could also influence that, your desire. I mean, it's all kinds of things. It's like lawyers at the end of the day are humans too. And, they want recognition. So a client that would cause them to be recognized by way of the media, being at their doorstep to interview them on a daily basis about what their client did or what they can say. Marketing, it would certainly help in marketing. Like, okay, I might lose this case, but 200,000 people are going to see me every other day on the news. I'm going to get some business out of that, right? So there's reasons for that. I'm just going to take one extra step that Professor Wendel didn't in regards to rule of law. Is we do live in a society, a constitutional republic. We have a constitution that guarantees that people have a defense, especially with the Harvey Weinstein situation. Even if a lawyer was to say, well, I'm going to represent you, I could choose not to, but I'm going to. This, in every prosecution, the state has an obligation to prove the elements or the case, to prove the person is guilty. And for a lawyer to just, step back and say, no, we're not going to force the state to go through the steps of proving somebody guilty is almost not defending the Constitution. And every lawyer took an oath to defend the Constitution and the rule of law as much as anything else. So I think that lawyers, maybe not in the same standard that a doctor has an obligation to repair somebody who is sick, but a lawyer does still have that same ethical responsibility to the rule of law.
Well, I think I agree with that, but I also just want to pick up on the first thing that you said about stage of career. So the way that I thought about the Ron Sullivan representation of Harvey Weinstein is that here the client is a multimillionaire, alleged. I mean, my daughter's a public defender, so I always say alleged, sex predator. Public defender has to take on every client for the constitutional reason. A criminal defense lawyer whose entire practice is criminal defense would say, look, if I turn down every client who's a bad person, I would be broke. That's a kind of career choice. Now we look at Ron Sullivan, who started as a public defender, and in fact, one of the top public defenders in the country, working for what is generally thought to be the best public defender office in the country, Washington, D.C. And then became a Harvard law professor. Now, his career was made defending, I think he would say, the downtrodden. Harvey Weinstein is a downtreader, not the downtrodden. So the question is, why do you, you're not a public defender who has to take the case. You're not somebody whose livelihood depends entirely on this. On the contrary, you are a highly compensated Harvard law professor. So everybody agrees Harvey Weinstein deserves representation by somebody. My question is, why does it deserve representation by you? Why are you doing it? Well, and the answer might be, I want to keep up my trial chops because that's part of my job. It might be, this seems like a really interesting case. It might be, he's just paying me a ton of money, and I'd like to get a third house. Now, Brad's book, I made a very important point, which is that when a lawyer is giving reasons for why they make a decision, the reasons ought to be generally acceptable. If I'm a member of the public, then I hear these reasons and I say, okay, you want practice. Good for you. I'm sure you can find plenty of cases in which you could keep up your chops. You want a lot of money. Well, why is that an answer to my question about why you're representing Harvey Weinstein? You want a lot of money. Congratulations. A lot of us want a lot of money. Is that a good enough reason? So I ended up thinking that he was answering the wrong question. He was appealing to this, what I'll call generic due process rhetoric, which is everybody who's accused of a crime deserves a lawyer. And my response is something that a famous civil rights lawyer once gave when he was asked, why don't you represent the Ku Klux Klan? He says, everybody deserves a lawyer. That doesn't mean that they deserve me. So there's an element of choice there. I'll just add one other thing. It's precisely because a criminal defense lawyer has maybe the highest obligations and zeal of any segment of the legal profession. That if you're going to offer that level of zeal to your clients, which I think you should, then it becomes especially important that you be held accountable for who you choose as your clients when you have that choice.
Yeah, I'm just going to real quick say, please go buy my book, because the through line in the book that I really wanted to establish is kind of builds off what David said, which is that giving reasons acceptable to others. You know, when it comes to ethics, the moral philosophy, I'm with the kind of relational ethicists, Tim Scanlon, Stephen Darwall, Jay Wallace, kind of come out of the Strawsonian tradition of the ethics arises out of an encounter between people where one person does something that affects the interests of another, and that person says, hey, why'd you do that, or how come you get to do this? And there's then incumbent upon the actor the requirement of giving a reason which needs to be acceptable in a certain way, and I think lawyers are subject to that as well. There's one thing I like about the Sullivan Weinstein story is that there's kind of a series of concentric circles of moral community, of the people who are very close to Sullivan, people to whom he owes other kinds of duties, the students at Harvard, other lawyers, members of the political community more generally. And the thing that I really wanted to do in the book is to keep lawyers' moral agency active. And I worry a lot about generic due process arguments or the strong form of the principle of non-accountability, which makes these sorts of conversations off limits. I want them to be on limits in the game or whatever, so that lawyers are engaging their moral agency in maybe even hypothetical responses to members of the political community who criticize them. Once you shut down criticism altogether, lawyers lose the habituation of thinking through what reason could I give that is acceptable to members of the political community. In other words, they fall back on the just doing my job excuse, which I don't want ever to be the way role morality is thought of. I'm a strong defender of role morality, but whenever I teach this stuff, like in a theoretical seminar, I say the field of legal ethics is haunted by the ghost of Eichmann. And we really have to worry about the kind of Nuremberg defense of just doing my job. I'm being a little hyperbolic, but the idea is you need to make sure you're not just offloading the moral responsibility onto the institutions and roles. And I think the discipline of responding to criticism is a way to keep moral agency engaged.
And if I could just add one other thing, I think the part that really annoyed me about the debate around Sullivan was people, I think especially in the legal profession, who would say, well, could you turn down the job because the client is too unappetizing? Thought, oh, no, you can't do that. But he could turn down a lawyer who says, I turned down this client because they couldn't pay my $50,000 retainer. Oh, that's fine. I mean, that just seems screwy to me.
I want to move to one more topic before we open it up for Q&A. So if you've got some burning questions, hold on to them for just a moment. I want to think just a little bit about the public sphere. So like government lawyers, you might think, and especially, and if any of these considerations change. I'm thinking about cases where you're not defending a client, but you're sort of like acting in their interest. So like you're a lawyer in the Bush 2 White House or the Obama White House, and there's cases where they've written legal memos that seem to justify things that the administration wants justified, whether that's enhanced interrogation or torture or extrajudicial killings in the case of Obama. So how do we think about that? Does anything change when we think about what the lawyer should be thinking about when they're advocating in a public sphere? And I'd be interested in what both of you think about that. And also, Judge Felix, I know you were a public prosecutor, so there's a kind of a experience in that kind of role too, where you're kind of told what to do rather than get to make as many decisions.
Well, let me just start with the role of the public prosecutor, where, I mean, this is not written into binding rules, but it's the accompaniment of every binding rule is that the duty of the prosecutor is not to seek victory, but seek justice. And there's something a little bit kind of, like, what are you talking about? What do we mean by seek justice? But it means that, and the argument that the Supreme Court gave when it came up with that dictum was that you're, as a government lawyer, as a prosecutor, you're not just representing a private client, you're representing a sovereignty whose laws ought to extend to all of us. And that's why, as a public prosecutor, you are not the rock'em sock'em victory at all costs defense lawyer who's got a constitutional obligation to that client, you also have a constitutional obligation to the sovereignty. And I think that government lawyers, I mean, let's just talk about the federal government. I mean, I think that we can make parallel arguments about state and local. But the President of the United States has a constitutional obligation to take care that the laws be faithfully executed. And I think that government lawyers inherit the president's obligation to take care that the laws be faithfully executed. And unlike a lot of I mean, there's been a lot written about what the faithful execution clause means, but I put a lot of weight on faithful. And I think that means that government lawyers should not be loopholing the law. I began thinking about this when revelations came in 2004 about how the United States was torturing people, torturing captives. And a leaked legal memo, a pair of legal memos, eventually 7 legal memos gradually released, was that government lawyers were loopholing the law in order to justify this. Now, US law says that torture is a serious felony. 20 years. If the torture victim dies, it's a death penalty offense. And the government lawyers were trying to figure out a way to get around that. And I think they cut a lot of corners in doing it. And the reason they did it, let me give their side of it. In the wake of the 9/11 attacks, there was an incredible amount of fear in the year 2002 that Al-Qaeda was going to launch a first anniversary attack. We need actionable intelligence. We need it fast. We need it above all. The atmosphere of panic in the highest levels of our security apparatus was an absolute maximum, as people in the apparatus reported. The President of the United States signed off on the torture program. The Vice President signed off. The National Security Advisor signed off. The head of the CIA signed off, and it's now kicked to some lawyers. Are you going to allow this to go forward? They're under incredible pressure to give the client the answer that the client wants to hear. And a lawyer in the advisory role, that's not your job. Your job is not to give the client whatever answer they want to hear. Your job is to give, I mean, in the terms of the rules, candid and independent advice. And to me, the rule of thumb about that is you give the same advice about what the law requires that you would give if your client wanted the opposite of what you know they want. And that was not happening. When the memos leaked, it became an incredible embarrassment because people said the way they're interpreting the law is like some bizarre literary deconstructionist, or the way this reads like a brief for like these guys are mafia lawyers, trying to figure out a way to get the torturers off the hook. And I think that there's a real violation of faithful execution in the constitutional sense if you are loopholing the law in order to get the client the answer that they want, even though the law doesn't permit the answer that they want.
What was your experience?
It only kept me angry for 14 years.
I'm just curious, what was your experience, Judge Felix? I know you were a public prosecutor for a while, doing things that maybe, like, do you have any, what was that like, being maybe told to do things maybe you didn't want to do? Or
Yeah, absolutely. So I served as a deputy prosecutor right after graduating from law school and served for 10 years in a local prosecutor's office. And one of the things I think we still talk about this, at least amongst my prosecutor friends, saying that the public defender is the defense attorney is kind of a misnomer, because the prosecutor, and this is the way we used to describe it, truly is the first defender for you. The public defender, the first public defender is the prosecutor who gets the police report, and the police officer is describing an offense that is not supported in the police report, right? The police officer wants somebody to be arrested for burglary, and the facts in the probable cause affidavit do not support a burglary. The police officer may have arrested the person already for burglary. It's the prosecutor's job to go over that police report, that probable cause affidavit, and make a determination whether or not the facts support those allegations. So we would, on a fairly regular basis, choose not to file charges against people who were arrested, right? So in that way, we were defending the public from overzealous law enforcement. And not only that, now there are situations where I was told how to prosecute a case, but there are also many situations where I was given the ability to make decisions. And the examples here are, now all of you are going to think this is ridiculous, but 30 years ago when I started prosecuting, we were still dealing with a war on drugs, and the elected prosecutor at the time wanted any person who was arrested for the possession of marijuana, even the smallest amount of marijuana, had to go to jail. Right? Now, it's almost ridiculous to think about it with half the country legalizing marijuana and some prosecutors in the state that have publicly announced we won't prosecute for that offense. But 30 years ago, we had to give plea offers to defendants that required them to go to jail for the simple offense of possession of marijuana. I couldn't not do that. That was something I was required to do. To give an offer that allowed someone to just go on probation would have caused me to be fired. So that was the offer. Now, a lot of defense attorneys who realized that the judges in the county would never give a weekend in jail started having their clients just plead guilty. No plea agreement. We don't want a plea agreement. We're just going to plead guilty. And the trial judge would give the person a sentence less than what my plea agreement would have been. And as soon as the defense attorneys found that out, they just started pleading guilty. However, I was also given a lot of discretion in regards to how I prosecuted a case. And my example there will go back to the days when I was a domestic violence prosecutor. When I had a case that was presented to me as a domestic violence case, and I reviewed the facts, and I listened to what the victim said at the scene. I listened to 911 tapes, and made a determination that the crime didn't really happen. I had the authority to dismiss the case, even though I'd already filed it. If I had believed later as the case was proceeding that the victim was really the initial aggressor and the defendant was defending, I'll say him because it usually is, defending himself, then I was allowed to dismiss the case. I was allowed to make those determinations. Similarly, if we filed the charge as a simple misdemeanor, and later I found out that there was more injuries, I could increase the penalty.
So yeah, this seems very consistent with what Professor Luban was saying about the duty of being faithful to the cause of justice and having some discretion about what justice requires in these cases.
For instance, I had a case once where a guy broke into a house where the woman had run to avoid being injured by him, and he broke down the door and went in and injured her. So we initially filed the charges of battery and residential entry. Well, when I made an offer for him to plead guilty to the battery and we dismissed the residential entry, he declined it. He rejected the offer and said he wants to go to trial. Now, he wanted to go to trial because he believed his girlfriend, maybe wife, would not testify against him. So He rejected every single one of my plea offers and said, we're going to trial. Well, on the way to trial, I added a charge of burglary, which essentially means breaking into somebody's house with the intent to commit a felony in it. And he battered her so severely that it would have been a battery as a felony. So I added more risk to him to go to trial. So if you're gonna play the game of I don't think the victim's gonna testify, then I can do that too. And although he didn't think the woman would show up, and truthfully, up until the moment I saw her in the courtroom, I didn't know if she was going to show up. She did, and she testified against him, and he was convicted of all the charges that were filed against him. But it's this discretion that I think prosecutors have, and the ethics, the morality of it. I don't know. Did I end up overcharging him because he wanted to go to trial? Some people might argue I did, but it was also, I think, a risk that he knew he was taking, and he took it.
This is great. So one last question before we go to Q&A. I think it's been really interesting to me to think about the professional duty versus that moral obligation. So I know a lot of students here are interested in law school. What would you say, just your quick advice, if they're worried, like, how do I go to law school, become a lawyer, and keep my integrity? What's your advice? We'll start down there with you, Doctor.
All right, I'll say something. Contrary to a lot of what we're doing here in this panel, most of what most lawyers do most of the time doesn't present all of these issues. You can go and be a good ethical lawyer in a lot of situations without any pressure on your integrity or moral agency. I teach law school, so you teach the exceptional cases, you teach the memorable cases, you teach Paul's Graph versus Long Island Railroad. That kind of stuff doesn't happen most of the time. Similarly, the Alton Logan case doesn't happen most of the time. Most of the time, you go in and you do a really routinized job, and it's fun and challenging, but not morally fraught most of the time. But it can happen, right? And there are decisions that have moral significance. What kind of employer am I going to work for? What kind of clients am I going to represent? What kind of practice area do I want to involve myself in? So, don't lose sight of that. But please don't let us make you think that most lawyers are going to wake up and get the confession from their client and go, "Oh no, what do I do now?" It's actually a great job, a great profession. I love practicing law, and 99% of the time, I didn't worry about the effect of that on my integrity.
I think that's really important. I mean, it's just like if you take a bioethics course, then you end up thinking that if I'm a physician, in the morning I decide which client gets the or which patient gets the organ transplant. Then I go on to should I pull the plug? Then I go on to, I mean, it's not like that. And it's the same thing in law. I mean, most cases don't challenge your integrity. I think that one of the things I would say as a plus, and this is very much in line with Brad's view about how we live in a pluralistic society in which people have different views, is inevitably you will have clients you don't like if you have a long career in the law. You'll have clients in which you think this person wants something that they don't really deserve. But mostly, you think this isn't the Alton Logan case. This isn't somebody going to prison for 26 years. So you broaden your perspective a little bit, which I think is a good thing. You can see things from the point of view of somebody who you fundamentally disagree with. And if you see things from the point of somebody that you fundamentally disagree with, it doesn't mean that all of a sudden they've changed your mind, but you think, yeah, this is someone that I can represent. And if I represent them, the things that I have to do to represent them, they aren't these really extreme things most of the time. So, I think that this is a way in which law school actually turns us into better citizens than many people would be if they didn't go to law school.
So, for those of you who are in the audience that are thinking about going to law school, I hope that there are things that were said today, or things that we might be able to say during the Q&A, or even afterwards, that will continue to encourage you to go to law school, especially if you have a desire to stay in Indiana. Indiana currently does have a lawyer shortage. There are some counties in the state of Indiana that literally have no more than 2 lawyers. And that is the number of lawyers that you need to have a
One's
prosecutor and a judge. And then, the defense attorneys come in from other counties. We need lawyers in this county. There's very few professions, I think, at this point in our country where you go to law school and you can almost guarantee that you will find a job in a prosecutor's office, which is also short of prosecutors. Defense attorneys, public defenders' offices are scrounging for attorneys to work in those offices. And I would absolutely try to encourage you to continue thinking about going to law school. As the 2 professors have already said, there are very few times in your entire legal career where you will deal with a situation where you are concerned about your integrity, the morality, how you feel. Can I go to sleep at night if I represent somebody, or this person or that person? Very few times will that ever happen.
Great. Well, thanks very much. Let's thank our panelists, but we're not done. I'm going to turn into a different role here, talk show host, and I'm going to carry the microphone around. So if you have a question for our panelists, please raise your hand. I see a few questions here, so I will bring the mic around. We've got about 15 minutes, so try to keep your questions short if you can.
Professor Seacrest's legal ethics class has been discussing this a little bit. We wanted to know, Wendell and Luban, what your answers were. Are you guys more instrumentalist or proceduralist when it comes to the legal system?
Nobody's ever accused me of being an instrumentalist before. I mean, I'm a very strong believer in procedural regularity. So I say that, if that's the dichotomy, I think of an instrumentalist as the end always justifies the means, and I don't think that's true. I think that there's just incredible importance in going through the right processes. I think maybe the only place that I would significantly differ with proceduralism is if the procedure just completely is blocking out your own conscience.
I'm sort of, if I didn't exist, you'd have to invent me, because I'm the proceduralist that is the foil for everybody else's arguments. So all the people who think that being a lawyer is fundamentally about justice or doing the right thing need to beat me up. So Bill Simon and Alan Hutchinson, and they need to write these mean things about me. So no, I'm a proceduralist. I mean, I really do believe that the institutions of the legal system exist for a morally valuable purpose, and lawyers should sustain those and work within that. And sometimes, and this may be experienced as a moral injury or a moral remainder. Sometimes have to tolerate injustice or harm as a result of what they do, and that can be one of the hard things, is when you're doing something and you realize, I could have made the world a better place, but my role doesn't allow me to do that. And I think that's just one of those costs that lawyers have to bear.
Thank you.
Hi, are there any reasonable alternatives to adversarial justice systems?
Well, there's systems that are designed, fundamentally, kind of hardball adversarial systems in which the judge is not an active participant and the parties are kind of going after each other. There are alternatives to that in many European countries and Latin American countries, where the system is called the civil law system. Judges are the active questioners at trial. They're asking, and the lawyers take a somewhat more. I mean, they recede a little bit more at trial. Um, one of the things that I got interested in really early is which is better at finding the truth, and it's everything that I've been able to research about it is that it's kind of a wash. I mean, there are pluses and minuses to both. I mean, I think that, um, uh, and there's really two kinds of studies. I mean, you don't know when the courts haven't found the truth mostly, so that's very hard to study in the field. But you can talk to experienced practitioners and get their views about it, or you can try to model it in the social psychology lab. And when you model it in the social psychology lab, they're just completely awash about which one is better at unearthing the truth.
There was maybe about 20 years ago, there was a gigantic vogue for alternative dispute resolution. The idea is we got to be mediating more disputes, or we got to have arbitrations. Arbitrations, by the way, have turned completely into full-on trials. But there are various kinds of alternatives that exist in some jurisdictions, and some there are problem-solving courts. My county, where I live, has a drug court where it's not really about prosecutor versus defendant, but the judge is involved in trying to figure out a good treatment plan for someone and help them get reintegrated into society as opposed to just punishing them. There are restorative justice movements that are based on reintegrating someone into the community. So there are all kinds of ideas that have been imagined about alternatives to adversarial adjudication, including the civilian system. Although I have a colleague who's a civil law specialist, and what he says is that actually, if you study how civilian adjudication works, it starts to look a lot like common law adversarial litigation. The parties counsel play a lot of role, and there's a kind of an adversarial mindset. But within the US, what's interesting is when you try to have mediation or restorative justice or problem solving courts, lawyers are just so trained from the get-go in our system to be adversarial. Day one in class, okay, you're the plaintiff. What do you argue here? Okay, what's the defendant going to argue? Like you're constantly putting people in that rhetorical space of responding to an argument and making it on behalf of your client. Like, what's the defendant going to say here? That's just baked into the way we train lawyers. So if we were to move away from adversarialism in any meaningful way, we would have to really rethink legal education from the ground up.
There is a push, I don't know if it's countrywide, but at least in Indiana, there's a push in family law cases for lawyers to attempt not arbitration, not mediation. I wish I could come up with the name of what.
Conciliation or something.
Maybe a conciliation court is where the attorneys essentially work out a contract with both clients. There's two attorneys, two clients, and they write up a contract where they say, we will never go to court. Right? Every single issue that we ever deal with, we are going to work out because it's in the best interest of ourselves, or the best interest of our children, or the best interest of avoiding court. Because nothing good, especially in family law, ultimately comes out when you go to court. Somebody gets beat up in court, right? Whether it's the wife or the husband, or the children end up in the wrong place. Somebody, you attempt justice. Here I am, a trial court. I used to be a trial court judge, and I'm saying this as I would do everything I could as a trial court judge to get lawyers to try to get a case worked out before they would come to court to see me. And to some extent, to try to answer your question, one of the things that we used to do is I would encourage the lawyers to ask me to what we would suggest is cast a shadow. The facts aren't in dispute. The facts are going to be this. How do you think you might rule? And we'll go out and talk to our clients and try to get a resolution along those lines. That way they avoid coming to court and making one side look ridiculous, or insulting one side, or bringing out bad facts, dirty laundry that nobody wants to bring out. So there's different things that we're attempting as opposed to adversarial justice. But, there's always the backup, the conciliation court. If that doesn't work out, the backup is always going to court. So.
Thanks. Good question. We got one over here.
So this was quite interesting for me because I've had to. I said panel discussion was quite interesting to me because as a lawyer who qualified in Nigeria, I've had to confront some of the issues that were discussed today, especially when we were compelled by my senior partners at the law firm to defend a rapist who kind of raped a young girl. So there was the moral issue there. And I teach gender law at DePauw here. And one of the questions that came to my mind listening to this panel is whether or not women are expected to a higher standard, a higher ethical standard when it comes to ethical response. Um, I think of a woman defending Harvey Weinstein, for example, and I wonder how that will be perceived. So, do you think that women are expected to behave more ethically, or it's the same standard for everyone?
Um,
About women clients or women lawyers?
Well, I think Harvey Weinstein actually hired a woman defense lawyer as a kind of prop. I mean, I think there are really interesting questions there about whether that's perpetuating sexism, or because what he's trying to do is to say, I'm not so bad. Look, I got a woman to defend me. There's a little bit of a show going on there. I don't think women are clearly not explicitly held to higher standards, but does sexism pervade the legal system? Of course. Are there different expectations about what men and women permissibly may do? Sure. We used to have these in-home seminars at my law school, and my wife and I taught for a number of years a class on women in the legal profession. And one of the themes that kept coming up is the double standard for women, right? You've got to be more competent than men, but there's the risk that if women come off as super competent, then they come off as, you can all fill in the blanks, shrill or bitchy or harsh or whatever, right? I mean, so that there's this very narrow tightrope that women have to walk. And that's a way that societal sexism has an impact on the legal system. It's not anything explicit, but certainly a judge, opposing counsel, a jury, someone may react differently to a woman doing something, whereas they would have no problem with a man doing it. For example, women famously in negotiations get penalized for kind of going hard in negotiations. So the advice to women often is make it sound like you're being altruistic, make it sound like you're really interested in someone else and not yourself, whereas men can be hard charging, and that's okay. So that kind of double standard, that kind of subtle sexism is pervasive, but clearly not explicit.
Yeah, I mean, every 15 years or so, the bar does studies of gender bias in the courts, and the gender bias is always there. It goes. I think that the last study showed less of it than in the past. I mean, one of the things that I think has been helpful has been the changing demographics of the profession. As women, there are just more and more women entering the profession, then it's less anomalous, and I think that the gender bias, while it's still there, just diminishes more.
Great. I think we've got time for one more question here. So there you go.
Thank you for being here. Sort of going back to this governmental question of these loopholes. Two parts to this. One, sort of, how do you as a lawyer balance the threat of your job on the line with, if you don't comply with finding these loopholes for your boss, especially if your boss is the president, say? And then two, is there any merit to thinking as one of these lawyers that maybe, well, okay, I'll write this loophole, but then I might be able to, this will give me an avenue to stand up to other things that might come down the pipeline, rather than just resigning and letting someone else take over, where there might be more lenient to providing these loopholes for the president or your boss in that case.
Yeah, there's I mean, this is a question that I think we're seeing played out in the headlines every week now, as lawyers in the Justice Department are resigning or getting fired, or just thinking about, can I stay in the job or not? The last thing that you mentioned, there's something that in the literature is called the effectiveness trap, which is I'm in this job where I can actually make a difference. Um, but to keep my effectiveness, I can't push back on everything. So I hold my fire. in the meetings. I don't say that something's wrong, even though I think that it's wrong, because I want to maintain my bureaucratic effectiveness. And then the next issue comes, and I hold my fire because I don't want to be cut out of the loop. And the 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 effectiveness trap is that you get trapped into thinking into a kind of learned helplessness, in which since I always want to stay in the loop and effective, I'm effectiveness. I keep my effectiveness without ever being effective.
This is going to sound like such a cliche, and I'm so sorry about this, but history takes a long view, and um, this isn't so much for line level lawyers. If you're in AUSA and you're in Minneapolis, you have your own concerns. But we were talking about the torture memos, and the two lawyers in the Office of Legal Counsel who worked on that, John Yu and Jay Bybee, will always be remembered for that. Jay Bybee's now a Ninth Circuit judge on the U.S. Court of Appeals for the Ninth Circuit. By all accounts, a pretty good judge. When his obituary is written, I'm sorry to say there's going to be a paragraph in there about his role at the OLC and the torture policy. That stink is going to follow him for the rest of his life. John Yu takes that on proudly. He's kind of leaned into that. But there are a decision that important is going to follow you around. And I don't know how far that goes down the current Justice Department. Todd Blanche, I can tell you what his obituary is going to say. Pam Bondi, I mean, the lawyers who are at a senior enough level that they can influence decision making, and they're doing things that they wouldn't be proud of when viewed in hindsight, they're going to have to answer to that. And I know it's a cliche, but I think it's important to keep that in mind.
Just, Don, I'm going to ask another question. It's like, I guess I'm trained as a judge to ask questions. You mentioned history takes the long view, right? And in these torture memos, where the U.S. government was torturing prisoners in order to try to get information about a potential next terrorist attack, right? There was no additional terrorist attack that happened. So therefore, the torture that was occurring, we look at today, rightfully so, as bad. Had those acts found information of the next terrorist act that we were then able to prevent, would those memos be looked at differently today?
Yeah, I mean, this is a hard hypothetical, but I think the question could be posed: could suppose that there was important counterterrorism information that was obtained through torture? Could it have been obtained some other way? One of the things that really blew me away about the torture memos was that was not something that was even tried. That is, the memos, they begin the way that lawyers' memos do. You have given us the following set of facts and asked us to answer this legal question. Among the facts are that when you are interrogating a high-value detainee, they get one chance to give actionable intelligence. And if they don't in that one chance, then the protocol begins. So the question, could you have gotten this life-saving information by other means? Never even got asked. And I mean, there's been a lot written about the empirics of, does torture work? What does working mean? I've always thought that that's kind of the wrong question. I mean, you start by asking, is this right or wrong? And if it's wrong, I mean, look, murder is very effective.
I was going to say, I think we've found our next topic for our next panel here.
Is murder effective?
No, not that.
How well does murder work?
Yeah, right. Yeah. Maybe we'll invite you guys back for that. No, this is really interesting. Lots more to say. I want to say just two things in closing. First, we're going to put up on the screen a little QR code. If you don't mind filling it out, helps us know how you enjoyed this and how it went. That'd be great. And most importantly, please join me in thanking our panelists once again.